California has launched a major legal battle against the Trump administration, marking one of the most significant state-federal confrontations in recent memory. The Golden State, known for its independent streak, is once again at the forefront of a national debate over the limits of federal authority. The state is suing over the federal government's controversial decision to take direct control of California's National Guard and deploy troops to Los Angeles. This move, made without the state's consent, has sparked outrage among California officials and residents alike. The stated mission for this deployment is to protect federal immigration enforcement agents operating in the state. Federal officials argue that the presence of the National Guard is necessary to ensure the safety and effectiveness of immigration operations. But California calls this a massive overstep, unlawful, unnecessary, and a direct violation of state authority. State leaders argue that the federal government is trampling on California's rights and undermining the principles of self-governance. The Attorney General is leading the charge, forcefully arguing that local law enforcement was fully capable of maintaining order and that the state had not requested federal intervention. He insists that California's own agencies were prepared to handle any situation that arose. If extra help was needed, the state, not Washington, should have made that call. California's leaders believe that decisions about public safety and resource deployment should remain in the hands of those closest to the communities affected. The federal government bypassed California entirely, igniting a fierce legal and political dispute that has captured national attention. The clash highlights deep divisions over the proper roles of state and federal governments. The lawsuit, filed in San Francisco, accuses President Trump of exceeding his constitutional authority by commandeering state resources for federal purposes without state approval. This isn't just a policy disagreement, it's a fundamental challenge to the legality of the president's actions. The case raises profound questions about the separation of powers and the rights of states under the Constitution. California is using the courts to defend its rights and push back against what it sees as federal overreach. State lawyers are preparing for a lengthy legal battle that could set important precedents for years to come. The state insists the federal government can't commandeer state resources for a mission the state opposes, especially when it believes those resources are being misused or diverted from their intended purpose. At its core, this case is about federalism, the delicate balance of power between state and federal government. The outcome could have far-reaching implications for how states assert their rights in the face of federal directives. The outcome could redefine how states and Washington interact for years to come, potentially shifting the boundaries of state sovereignty and federal control. All eyes are on this high-stakes showdown, as the nation waits to see whether California's challenge will reshape the relationship between the states and the federal government. California's lawsuit is rooted in the 10th Amendment, a crucial part of the Bill of Rights that shapes the relationship between the states and the federal government. The 10th Amendment reserves powers not specifically granted to the federal government for the states themselves, serving as a constitutional safeguard for state authority. In this case, California argues that President Trump overstepped these boundaries by federalizing the National Guard without the governor's consent, a move that bypassed the state's own leadership and traditions. Governor Gavin Newsom, who serves as the commander-in-chief of California's National Guard, was left out of the decision-making process, a step California officials describe as both dangerous and unprecedented in modern American history. The legal complaint frames this action as a direct attack on state sovereignty and the delicate constitutional balance of power that has defined the United States since its founding. California's case isn't just about a single incident or a disagreement with one president, it's about defending the broader system that determines how state and federal governments interact and share responsibilities. The lawsuit raises a fundamental question that echoes through American history. Who ultimately decides how a state's resources, like the National Guard, are used? The state's elected leaders or officials in Washington, D.C.? California's answer is clear. The state should control its own resources, unless there is a genuine, clearly defined national emergency that requires federal intervention. The Trump administration's actions directly challenge this long-held view, setting up a legal battle that could redefine the boundaries of federal and state power. The court's ruling in this case could have far-reaching consequences, potentially reshaping the balance of power for years to come, especially when it comes to the use and control of the National Guard within state borders. This case forces the nation to confront a core constitutional question. How far can federal authority reach into the affairs of individual states, and where should the line be drawn to protect state autonomy? California is urging the court to reaffirm the limits on federal power, to ensure that states retain the autonomy the Constitution promises, and to prevent future overreach by any administration. The stakes are enormous, not just for California, but for every state in the Union. The outcome of this case could affect how all states interact with the federal government for generations. The final decision could set a powerful legal precedent, shaping the future of American federalism and the balance of power between state and federal governments for decades to come. California's core argument is simple. The federal intervention was unnecessary. Local law enforcement was fully prepared to handle any issues, including those involving federal immigration agents. There was no crisis, no breakdown of order, no justification for federal troops. The proper process, if help was needed, would have been a request from local agencies to the state, not a federal takeover. The Trump administration ignored these protocols, sidelining state authority. California claims this was a political move, not a response to real threats. The lawsuit aims to prove the president's order was arbitrary and unjustified. California wants the court to rule that federal deployment of the Guard isn't allowed when the state says it's not needed. The state paints a picture of a calm, capable local response system pushed aside for politics. No emergency, no need for federal troops, just an unlawful act violating state rights. The Trump administration's likely defense centers on protecting federal employees, specifically ICE agents. The White House would argue it has a duty to ensure their safety, especially if it perceives threats or a lack of cooperation from California's sanctuary policies. From this perspective, deploying the National Guard was a necessary step to fill a security gap. The administration would cite the president's constitutional authority as commander-in-chief and his responsibility to enforce federal law. They'd argue this power isn't limited by a governor's disagreement, especially for core federal functions like immigration. The administration might present intelligence or threat assessments to justify the deployment. Their case, this was a prudent, necessary response to real risks, not an arbitrary power grab. The debate shifts from state rights to national security. The court must weigh federal responsibility against state autonomy. Tensions escalated when Defense Secretary Pete Hegseth announced the deployment of 700 active-duty Marines to Los Angeles. This move dramatically increased federal presence and raised the stakes in the California White House standoff. The use of active-duty military for domestic law enforcement is rare and controversial, governed by the Posse Comitatus Act. Many saw this as a major escalation and further evidence of federal overreach. The sight of Marines and National Guard troops in a major city fueled concerns about militarizing a domestic issue. California's lawsuit now addresses not just the Guard, but the broader implications of federal military presence. The Trump administration signaled it would not back down, using the full weight of federal power. For California, this reinforced fears of unchecked federal authority. The legal battle now symbolizes a deeper clash over the role of the military inside U.S. borders. Governor Gavin Newsom has taken his fight national. He warns other states, if the federal government can override his authority, no governor's power is safe. Newsom frames the issue as a threat to all states, not just California. He urges fellow governors to join the fight against federal overreach, arguing the precedent could weaken every state's control over its National Guard. Newsom's message, this isn't just about immigration, it's about the fundamental balance of power in America. He cautions that unchecked federal action could spill into other areas, from law enforcement to public health. By nationalizing the issue, Newsom seeks a united front of states. He reminds the country, the U.S. is a federation, not a centralized government. The question he poses, what if the president could deploy your state's troops on your soil, against your will? At the heart of this ongoing dispute lies the National Guard's unique and sometimes controversial dual role, serving both state and federal governments. This arrangement, while designed to provide flexibility and rapid response, has also created a persistent source of tension and debate over who truly controls the Guard in times of crisis. In most situations, the Guard answers directly to the governor, stepping in to handle emergencies like wildfires, floods, and civil unrest. They are often the first line of defense for communities in need, providing critical support and reassurance to civilians during some of their darkest hours. However, the president holds the authority to federalize the Guard, calling them into national service for missions that extend beyond state borders or address broader national concerns. This power is meant to ensure national security and unity in times of extraordinary need. California now argues that this federal power was misused, claiming it was invoked to support a domestic law enforcement mission that the state government strongly opposes. The state contends that such use undermines its autonomy and the will of its people. The resulting lawsuit directly challenges the idea that the president can override a governor's authority, especially when it comes to controversial federal policies that may not reflect the values or priorities of the state. Now, the courts are tasked with clarifying the true limits of presidential power to federalize the Guard, particularly in situations where state consent is absent or contested. Their decision will set a precedent for future conflicts between state and federal interests. The outcome of this case will have far-reaching consequences, shaping not only how the Guard is deployed in the future, but also redefining the delicate balance of military power between individual states and Washington, D.C. At its core, the issue is deceptively simple, yet deeply significant. When, and under what circumstances, is it appropriate for the president to take control of a state's National Guard, potentially against the wishes of that state's leadership? Historically, this extraordinary power has been reserved for times of war, or genuine national emergencies. Moments when swift, unified action is essential for the country's survival or security. California argues that using the Guard for federal law enforcement purposes, especially when the state government objects, crosses a constitutional line and threatens the foundational principle of state sovereignty. The state is asking the court to affirm that the Guard's primary mission is to serve and protect the state and its citizens, not to be used as a tool to undermine state authority or enforce unpopular federal mandates. Ultimately, this landmark case could redefine the National Guard's mission and identity for the 21st century, setting new boundaries for how and when the Guard can be called into service, and by whom. California's lawsuit has a clear goal: restore state control over its National Guard. The state asks the court to cancel the president's order and return command to Governor Newsom. This isn't just symbolic. A ruling for California would force the federal government to withdraw its command. It would set a powerful precedent, protecting other states from similar federal actions. California frames the lawsuit as a necessary step to correct an illegal power grab and restore constitutional order. The state is using the courts to enforce its sovereign rights. The central demand put the Guard back under state command. California wants to ensure its soldiers aren't used for federal missions against its will. The lawsuit seeks to undo the federal intervention and prevent future overreach. It's a fight to protect state authority and the traditional balance of power. This legal battle is about more than California. It could reshape the nation. The outcome will answer a fundamental question: how much power does Washington have to intervene in state affairs? A win for California would strengthen state rights and limit future federal takeovers of the National Guard. A win for the federal government could expand presidential authority and weaken governors everywhere. Every state is watching, knowing the result will affect their own autonomy. The courts are being asked to draw a new line in the balance of power. This case will set the rules for federal-state relations in times of conflict. It's a defining moment for American federalism. The decision will ripple across the country, shaping law and politics for years. The stakes, nothing less than the future of state and federal power in America.